Welcome everyone, this is Amer Mushtaq from U-Counsel. Today we'll talk about wrongful dismissal, and the issue that we'll be dealing with today is how do you figure out whether you as an employee are wrongfully dismissed or not. And so what we've done is we have posed 10 simple questions that you can ask yourself, and depending upon your answer to those questions, you will be able to understand whether you're wrongfully dismissed or not, and on that basis you can decide to pursue your wrongful dismissal action either yourself or through legal counsel. Okay, so we begin with our usual disclaimer that this course is not legal advice, so if you have any specific questions, you must contact a lawyer or paralegal to get the answers. We're going to start with talking about different terms that are used for wrongful dismissal, and some of the terms are wrongful termination, wrongful discharge, constructive dismissal, dismissal for cause, fired, sometimes people call a layoff. All these terms are similar. They can be used at times interchangeably, but they all represent what is called the wrongful dismissal, which is sort of a blanket term that we use in employment law. So what is exactly wrongful dismissal? Is it possible for me to explain wrongful dismissal in sort of one basic concept? And the answer is yes. So wrongful dismissal is it's basically a breach of an employee's employment contract. So that's the first part. And then the second part is that breach of the employment contract must be the breach of one of the fundamental terms of the employment contract. So what do I mean by those two things? So let's take breach of employment contract number one. Many people, and we'll have a separate lecture where we'll talk about what is an employment contract, and we'll get into the nitty-gritty of it. But over here, I just want you to understand that most people think that an employment contract is one when there is something in writing, two parties have signed it, there's a written document confirming that there's a contract, and that's how an employment contract is created. That's not necessarily the case. Once you have an employment relationship with an employer, you have an employment contract, whether it's in writing or not. So it doesn't matter if there is no written document, you have an employment contract. It is just an employment contract that is an unwritten employment contract. So that's number one. With respect to employment contract, I want you to sort of understand this. So if there is a written document, whether it's a job letter, job offer, or it's called an employment contract, all of these things could be similar or same. So if you have a written employment contract or written job offer, the terms and conditions that are specified in that contract are obviously part of your employment contract. But those are not all of the terms of your employment contract. There are and there will be additional terms that are not written in that employment contract, which are called implied terms. Implied terms means that those terms are assumed in your employment contract, even if they're not written in there. And that is because of the centuries of development in the employment law area, where the courts have sort of written in certain employment contractual terms which are not in writing, but they're there. So they're called implied terms. So your contract, if it's in writing, has two components. One's the written component and one is the non-written component, which is the implied terms. So the breach of your employment contract could be either for the terms that are in writing, or could be the terms that are implied, or could be both. So that's number one. And number two, the breach has to be one of the fundamental terms. So what is the fundamental term? Fundamental term is very simply one of the important, significant terms in the contract. I'll give you an example. So let's say your employment contract says your annual salary is $60,000, and once you begin employment, you start getting paid on the basis of $30,000. That's your salary is a fundamental term, and the breach of that term is a breach of fundamental terms of employment contract. So let's say another example could be that you are hired as a manager of accounts payable. And once you start working, you have been your position actually is that of an accounting clerk and not as a manager in the accounting. And so that's a fundamental term. Your position is a fundamental term, and then a breach of that term could be a breach of your employment contract. So that's sort of just a broad example, so you understand the basic concept The wrongful dismissal essentially, so if there is a breach of your employment contract, and the breach is one of the, breach of one of the fundamental terms of that employment contract, then that breach or those breaches can give rise to an action or a claim for wrongful dismissal. So that's the fundamental concept. Okay. Now, jumping right into the kind of questions, and these are sort of examples. There could be more questions, but we've picked sort of the most, 10 most common questions, and we're going to address those. So first part of the question is when you're actually terminated. And so what I mean by that is your employer comes to you and says, so-and-so, your employment is ending. This is your last date, or such and such date is your last date, and you're terminated. You're fired, you're laid off, whatever you want to call it. If the general term is that your employment is ending, then that's a termination. And so these, I believe 6 questions are when you're actually terminated, that your employment has been ended by the employer. So one scenario could be that you did not receive severance at all, or the severance you received was improper or insufficient. The second could be breach of written contract. So remember I said that your employment contract would be in writing, and if it's in writing and there's a term in that contract, and that is being breached by the employer, you want to look at that. So you want to check that out. So that's a question, whether there's a breach of written contract. Question number 3 is whether there's a breach of your statutory rights. They're not fulfilled by the employer. Question number 4 could be whether your termination is based on discriminatory grounds. Question number 5 is whether the employer conducted itself in bad faith in deciding to terminate you. That's another question. And the last question is that the employer is alleging just cause for dismissal, that you have done something fundamentally wrong, and then the employer has a right to terminate you for just cause. So those are the 6 questions, and we'll go into each question one by one. And we'll quickly cover those topics. But those are sort of 6 questions. When you're actually terminated, that you're terminated. Now, the next 4 questions are when you're not terminated. The employer has not come to you and said your employment is terminated. But you believe that the breaches are such that you can claim termination. It's called constructive dismissal. So you are constructing it based upon the employer's conduct that your employment has ended. So there are 4 questions relating to that. One is sort of change in duties. If there's a fundamental change in your duties, it may give rise to constructive dismissal and therefore wrongful dismissal. There may be change in your remuneration, especially a decrease in your remuneration. Change in working environment. The environment has become harassing or poisonous. Or there could be a breach of your written contract. So these are sort of 4 questions that you want to ask yourself to determine that even though the employer has not terminated you, do you have a right or grounds to claim constructive dismissal and wrongful dismissal. So let's get into each item one by one. So no severance or improper severance. So remember, this is sort of the most common reason for claiming wrongful dismissal. In fact, 60 to 70% of my employment law practice is really based upon clients coming to us and asking questions whether they received proper severance because they're terminated, and if not, then can we commence a court action? And in over 90% of those cases, the severance that they receive is actually not correct; it's improper, and so there is usually a case to commence a wrongful dismissal action. So that's sort of the most common reason that the employers refuse or fail to provide the employee proper severance, and so we go after that. Now, with respect to your severance, we want to talk about 3 things. Severance, you may have contractual rights in the severance, and what I mean by contractual rights is we're talking about the written contract that you have. So your written contract may say that, Mr. Smith, when your employment is terminated, we decide to terminate your employment without cause, you will be entitled to 6 months of pay or something like that. So that's your contractual right in your written employment contract, and for whatever reason the employer fails to abide by that contractual term, and so that may gives rise to a wrongful dismissal action. So that's one. Common law rights. So even if there's no contractual rights, or the contractual rights are improperly drafted, unlawfully written, you have common law rights on termination, and in most cases this is what happens, that employee has common law rights and the employer either doesn't know about it or refuses to pay common law rights, so that gives rise to a wrongful dismissal. And then the number 3 is statutory rights. And remember, we in previous lectures, if you've listened to us, we talked about certain statutes that are relevant to employment law. So for instance, Employment Standards Act 2000 in Ontario, and other provinces have similar legislation that contain rights that describe that if you as an employee are terminated, are you entitled to any termination pay, severance pay, and what those amounts are. So if you're not receiving proper severance or no severance at all, then that's one ground that will give rise to wrongful dismissal action. How do you determine? And this is one area where you will be best served if you consult. You do your Google search and listen to our lectures, and that will give you a very good sense of whether you got your proper severance or not. But you may be better served if you contact an employment lawyer and get a consultation and find out whether your rights have been violated or not, because this is one area that's too complicated and a lot is on stake. Like, you could get significant rights and without and if you have no knowledge that your rights are violated, you may end up losing those rights. So that's sort of one area which is a bit complicated and something to be looked into deeply. Now, breach of written contract. Like I said, you have written contract, and it may have clauses about severance and termination rights, and if the employer doesn't follow those rights, then that's a breach which will give rise to wrongful dismissal. What about commissions? If you are in a position where you're entitled to commissions, you got your severance and termination, but you have unpaid commissions that you did not get, or commissions that you should have received even after your termination, and you're not getting those. That may give rise to wrongful dismissal. Similarly, if you're entitled to significant bonus and you don't get that, and there could be other rights, and it depends upon the contract, but there could be all kinds of rights that are in the employment contract that state what will be done, what things you will receive upon termination, and you don't get those, and you have a claim for wrongful dismissal. Now, breach of statutory rights, as I said briefly, that if you look at Employment Standards Act, it talks about termination pay and it has a specific formula. Let's say you didn't get those rights, or overtime pay if you were entitled to that and you didn't get it. What about severance pay? Severance pay is a separate pay category than termination pay. There are specific requirements for that in Employment Standards Act in Ontario and similarly in other provinces. Or any other rights that are stated in the statute and you are denied those rights on termination, then you may have a claim for wrongful dismissal. Discrimination. This is based upon a breach of Human Rights Code in Ontario. That's the human rights legislation in Ontario. There are similar legislations in the other provinces. And if you believe that you're terminated because of certain discriminatory grounds, so for instance, you ended up having some sort of disability, and that was the reason, or one of the reasons why employer decided to terminate you, or because of your gender, because of your sexual orientation, pregnancy, creed, religion, ethnicity, all these grounds are listed in Human Rights Code, and if it's a breach of one of those grounds, and that's the reason, or one of the reasons, or one of the factors in your dismissal, then you have grounds for wrongful dismissal. What about bad faith conduct? So bad faith conduct could be a variety of things where employer is acting in bad faith towards you, the employee. One example, it's actually coming from a case that I'm dealing with now, is really unrealistic demands. The employee goes away on maternity leave, comes back, and then her duties are changed to the extent that she's now required to work for 3 jobs as opposed to 1, which is impossible for her, and giving rise to a situation where she may seek constructive dismissal. Another example, which is not uncommon, is unfair performance evaluations, unfair appraisals. Employer at times trying, especially for long service employees, they try to build certain grounds so that they can build a case for the dismissal of employee for cause, and when all of a sudden, without any wrongdoing on your part, you get to see a series of wrongful, unfair evaluations, performance evaluations, and they may lead to a claim for wrongful dismissal too, or constructive dismissal for that matter. Surreptitious change in contract. This is something that's not too uncommon either, and this happens to long service employees, 20 years, 25 years, 30 years of service, where when the employer is coming to a point where they want to terminate their employment and realizes that they have a significant amount of severance to pay, they try to sort of bring in a new employment contract, and do it surreptitiously so that the employee doesn't know what he or she is getting into, does not get an opportunity to talk to a lawyer, and then ends up signing a contract which was completely unfavorable to him or her without realizing what she got herself into. So those could be sort of some of the grounds that may give rise to bad faith conduct and may give rise to wrongful dismissal. Now coming to just cause dismissal, which is usually the employer saying that you, the employee, have conducted yourself in such a bad manner that we should not give you any severance at all, and you just get your pay up to the last day, and then you're gone. You're not entitled to EI or anything, and that's called just cause dismissal. Sometimes the employer, not often, try to use an employee's performance as grounds for just cause dismissal. Most of the time, performance does not amount to just cause dismissal, but that's what it is claimed. Allegations about conduct. I mean, some of the legitimate examples of just cause dismissal are that, an employee has a physical fight with another coworker at the workplace, or harassed another employee, or conducted violently, or abusive language. These kind of things, or stole money from the employer, stole employer's property. These are sort of some of the legitimate causes for just cause dismissal. But any allegations about misconduct which the employer uses to say that you, the employee, are terminated for just cause, and if you believe that those grounds are not valid, those allegations are not fair, then you have a wrongful dismissal case against the employer. One thing that you want to keep in mind, and this is the most important part, is that just cause dismissal is really the capital punishment of employment law world. That's how you want to understand it. So small infractions here and there, lack of performance, things like that, they usually do not amount to just cause dismissal. Your conduct should be so bad. So for instance, if absenteeism is the ground for just cause dismissal, it has to be repeated, offenses, you're constantly ignoring the policies, and so on and so forth. So there's a cumulative conduct that shows that there's just cause. Or, the conduct is so bad, so severe, you defrauded the employer, you breached the trust of the employer by, breaching the confidentiality agreement, things like that. Those are sort of the valid grounds for just cause dismissal. But, lack of performance, inability, sometimes the employers will argue that you were supposed to sell, you're a salesperson, you were supposed to sell 100 widgets per month and you only sold 80, we have just cause against you. Not really, right? So if you are terminated on just cause basis, then you must ideally talk to a lawyer, employment lawyer, and see if there is a valid just cause under employment law. Let's quickly touch upon constructive dismissal, and I mentioned 4 scenarios, 4 questions: change in duties, change in remuneration, change in work environment, and breach of contract. So change in duties, I gave you an example that you were hired as a manager, but the employer decides to demote you unilaterally or by its own decision and makes you a clerk. Now that's a fundamental change of your terms of employment, even though you're not terminated, but the employer has changed the fundamental nature of your duties, and so you have grounds to walk out and seek constructive dismissal. Similarly, change in remuneration. If your remuneration is reduced by sort of 10% or more, then that sort of safely can be considered grounds for constructive dismissal. You're not, there are ways how you pursue constructive dismissal, and that's a separate topic. But change in remuneration, which is significant enough, can give rise to a claim for constructive dismissal. Change in work environment. So the environment you get a new manager who has a harassing behavior towards you, who is a bully, who acts and breaches in violation of the fundamental code of conduct. And so that may give rise to a claim for constructive dismissal, and obviously breach of contract. So an example could be that you're still working and you're showing up to work and you're being given tasks, but you're not getting paid and you haven't received pay for the last 2 months. And that could be another reason why you can claim constructive dismissal. So we've gone through 10 questions, and pose yourself these questions and see if you fit into one or more of these categories, and if you believe that the employer did not have the appropriate grounds to terminate you or has changed your duties in such a way that you can claim constructive dismissal, then that's the avenue that you can pursue. Okay, hopefully this was helpful. Please post your questions, comments, anything that you want clarification on, and we'll be happy to cover that in the next lecture. Thanks for listening.